Lawyers, have you ever had a moment in court when you deliberately lost a case because of your beliefs? Story 1. In undergrad, I took a law course taught by a former prominent defense attorney. Someone once asked why he left such a lucrative practice to teach, and he told us this story. There was a guy who, with his wife, had 2 foster children, boys around 10 or so. One of the boys got good grades, was a Boy Scout or something. The other boy was always in trouble in school, had been caught stealing and lying in the past. Well, the troublesome kid told someone that the foster dad, an esteemed community member, had been abusing him. The foster dad swore he never touched him. With the kid's background of lying and being in trouble, it was clear he had made this up, and that was the entire defense case. The boy took the stand, cried as he was called a liar. The defense was definitely going to win. Well, the day before closing arguments, the professor/lawyer meets with his client and tells him he's pretty sure they are going to win, goes over closing. Suddenly, foster dad asks if anything he tells his lawyer can be shared. The lawyer tells him it cannot. Foster dad looks at him and says, "You know all those things he said I did to him? I did those things. I feel bad about it and won't do it again. But thank you for believing me." My professor tried to get himself removed from the case, but because it was the day before closing arguments, it wasn't allowed. He won the case. Edit. I should add that the good kid said the foster dad had never touched him and was a good dad. This made the other kid look even worse. Obviously, this guy was a legit predator, because he chose a victim no one would believe. Story 2. Doesn't answer the prompt as I didn't win this one, but this is one I would have felt really bad winning, and I'm glad I convinced my client to back off. I do mortgage foreclosures. I had a client that was foreclosing on a property with a remaining principal balance of about $600. The owner of the property, old lady, had requested payoff figures to pay off the remaining balance of her mortgage. When she got them in September, they included money to be paid into escrow for property taxes due in November. She paid everything but the amount that would have gone to escrow because, by her reasoning, which I agreed with, if she paid off the mortgage before November, then whether the property taxes were paid was no longer a concern of the mortgage company. Well, my client applied some of the payment to escrow, so instead of completely paying it off, there was a remaining balance of about $600. She thought her mortgage was paid off and didn't make any further payments. Late fees built up. Then they decided to foreclose, and legal fees built up, until I saw the file and refused to move forward. They were paying me more in legal fees than they were owed. It was ridiculous. They had a legal right to do what they did, and to foreclose, and they kept insisting on that. I had to argue that that didn't mean it wasn't _wrong to do it, or that any judge I brought this to wouldn't find a way to make sure it never went anywhere. I eventually talked them down, and they wrote off the remaining amount due. The whole time the woman who was being foreclosed on was angry at _me_, and I couldn't tell her that I agreed with her and was trying to make the whole thing go away. To this day, I'm sure she thinks she beat me. Story 3. I've had a few. One of them I wrote about in my book, which was I represented. It was a case that I won that I should have lost. I represented a pimp. That's what he did for a living. And he owned a variety of illegal businesses. He's in prison for a long, long time now. But at the time, he had very brutally abused a woman who he had children with. And we went to. There was a family court proceeding, and the lawyer on the other side of the scene. Of the case, the lawyer who represented his co-parent, his victim, if you will, was very inexperienced. She was an assigned lawyer. So I was privately paid as I am, and she was assigned by the state. So she was getting, I think at the time, $25 an hour, something like that, versus my $750 an hour. And she was quite new as a lawyer. She was right out of school. She wasn't quite sure of what to do and how to do it, and I was fairly experienced. It was a perfect storm of the worst factors of the system. It was someone who could afford a very good lawyer against someone who couldn't afford a good lawyer, and therefore got an inexperienced lawyer that wasn't terribly sure of themselves in a courtroom. and a judge who was very impatient, who just was in a bad mood that day. I don't know what he had for breakfast or what it was, but he was an older judge. He'd been on the bench for probably too long. He retired a few years later. The key piece of evidence they had was a photograph of the way that of this woman's face after my client had allegedly beat her up quite badly. And getting a photograph into evidence is very easy, but it requires a very specific phrasing. So what you say is, "I'd like this to be marked for identification." You mark the photo and then you hand it to the witness. Or you hand it to the court officer, who hands it to the witness. And you say, "I'm showing you what's been marked as Petitioner's 1 for identification. Do you recognize that?" "Yes." "What do you recognize it to be?" "It's a photograph." "Does that photograph fairly and accurately depict your face after he beat you up, or does it accurately reflect your face on the date you've been discussing?" "Yes, Your Honor, I'd like it put into evidence." That's it. It's easy. Does it fairly and accurately depict, for whatever reason, most likely lack of experience? Opposing counsel, I guess, didn't know how to get a photograph into evidence. Now, normally in that situation, a judge will be helpful, like they will just jump in and say, "Ma'am, does this fairly?" But this judge was just not in the mood. And opposing counsel said, "I'd like this to be marked." And then she said, "Could you hand it to the witness?" And she said, "What is that a photo of?" So I did my job. I said, "Objection. She's asking about the contents of a document, not an evidence, which is my job." Judge said, "Sustained," which means my objection is correct. So she said, "Okay, I'm sorry, who took this photo?" And she said, "I don't know who took it." She says, "Okay, well, what is it a photo of?" Stood up again. Objection. Asking about the contents of a document, not an evidence. And I could see opposing counsel getting flustered because she didn't know the words. And my internal dialogue at that moment was just say it like, just get it right, like just say fair. Does it fairly inaccurately depict? Does it just say it like? And I remember looking at the judge and thinking, like, you're letting this happen. Don't let this happen. Like, she's poor. That's why she's going to lose. She's going to lose because she's poor and she can't afford a lawyer. And he's going to win because he can afford a lawyer that knows how to put a document. And there's something really wrong about that. And the judge didn't. The judge just let her drown. And she asked 3 or 4 more questions that were the wrong questions. And then she just said, I don't know. I don't know what to say. I'm sorry. And then she just sat down and the case got dismissed. And we walked out. And as we walked out, my client patted me on the back. And he said, "You know, a good lawyer is better than 20 stick-up men." And I remember thinking, this is not a good day. It's not a good day. In that case, that was a long time ago, and Story 4. I do a fair number of evictions as a result of holdovers after residential foreclosures. Often, entire families show up for the hearing. It gets to be where it is almost a template. Hysterical mom, stoic dad with a glint of anger in his eyes, angsty teen refusing to meet your gaze, and oblivious child/toddler wondering why everyone looked so sad. I sit down with these people and try to be as empathetic as possible. Most of the time they try to explain that they stopped paying because they lost their job or someone got sick. I nod and say I am sorry to hear that. Then I have to tell them that Story 5. I could tell from the report and all of the information that he was guilty, although he would not admit to such. He did not want to plead out, but wanted a trial. That's fine. That's always going to be the client's decision, and unlike some other people who I knew did what they were accused of, he didn't hem or haw about it. Trial comes. All of the bad facts come from other witnesses. The violent nature of the assault was clear from the evidence. She had been thrown into a wall, sustained injuries, including lost teeth, and had her hair set on fire. The table thrown across the room and broken. The interviews done by various law enforcement officers getting her statement about what happened. Objection to the hearsay, subject to corroboration by the victim, of course. The victim takes the stand. She is still in love with her man. She will do nothing to get him in trouble. She says she did all of those things to herself because she was mad. As the defense attorney, I ask nothing on cross-examination. It would be malpractice to try and get her to say what I know to be true. I immediately request a dismissal. We go to judge's chambers. The assistant district attorney knows I can't give her the information she needs. I'm bound by my duty of loyalty to my client. The judge, who's relatively new on the bench and was in civil practice before being appointed, asks a few questions that I know are inappropriate, and I tell him I cannot answer them. I remind him the state cannot prove anything beyond a reasonable doubt because of her testimony. We leave chambers. The case against my client is dismissed. He's kind and cordial and thanks me. Then the judge finds the victim, burns scars on her head and missing teeth and all, in contempt of court and locks her up for 30 days. That's a slice of my job. At least I can look to the Constitution and say, this is how it is supposed to work. I have also represented family law cases with similar sets of circumstances. I do not do family law work anymore. Too long. Didn't read since I failed to keep it short. You have to represent everyone, and some people are horrible, but my job requires me to represent them just as zealously as anyone else. Story 6. I'm going to go ahead and list my personal worst case and the worst I've ever heard during my career. A while back, I represented credit card companies suing for outstanding debts, where we had pretty stringent client guidelines dictating how we handled lawsuits. The bottom line was that we were to be aggressive in court so as to put our client in favorable positions during any settlement negotiations. One defendant was a 40-year-old woman who had maxed out all her credit cards in a futile attempt to pay for health care for her husband, who ultimately died of cancer. In total, she had spent something along the lines of $60,000 paying for chemotherapy, hospital stays, and various other bills. She ended up losing her job, husband, and home, all within the span of 3 months. She didn't even bother showing up for hearings or responding to the complaint, meaning my client won a default judgment against her. The worst part? I had to stand up and tell the judge what my client was entitled to. $60,000 for principal amount, $80,000 for interest and late fees, $10,000 in attorney's fees. She now has a judgment of $150,000 against her. I refuse to do that line of work anymore and have made it a point to represent people against credit cards if the opportunity presents itself. The worst came from a former law professor of mine. Brace yourself, it's ugly. He was a defense attorney whose client was accused of kidnapping, brutally assaulting, and leaving for dead a 5-year-old girl in an abandoned home. When this little girl was found, she had suffered severe injuries, including broken bones and significant blood loss, and was in a coma. After the brutal assault, the attacker left her in an abandoned home, believing she would not survive. Despite the fact doctors gave her a slim chance of survival, she managed to somehow pull through. According to my professor, he knew his client had done it, and the evidence completely supported it. Despite knowing this, he put on the best defense he could muster. The prosecution ended up calling the victim to the stand, who, keep in mind, was still just a child. They gave her a direct examination, cognizant of the ordeal she had been through, as well as her age. My professor then went up to cross-examine her. He grabbed a chair and sat down next to the girl in the courtroom so that he was on her level and asked her questions in the friendliest manner possible. He smiled with her, held her hand, told her simple jokes, made her laugh. For the first time since the attack, this little girl was smiling and seemed happy. My professor was so good at building a rapport with her that she couldn't help but feel happy with him. All the while, she was too young to realize that the gentle questions he was asking were meant to impeach her credibility and undercut the prosecution's case. When the questioning was done, she returned back to her family, smiling, and blissfully unaware that she had dismantled the case against her attacker. A week later, the victim and her family appeared in the courtroom on the day the verdict was to be announced. When the little girl saw my professor standing there, she ran up to him and gave him the biggest hug she could, remembering how nice he was to her. She was so happy to see him and told him thank you. A few minutes later, the verdict was announced. Complete defense verdict. Story 7. Would my personal morals, for example, allow me to get someone off when I know they are going to do it again? And when it was posed this way, I struggled with answering in a way that didn't make me feel like a terrible person. It was like I was saying I personally agreed with causing harm and abuse, because my morals required me to be legally ethical in my pursuit of a zealous defense. Why do we have an exclusionary rule if we, as a society, understand that by excluding evidence seized in violation of the Fourth Amendment, we may release someone who does it again? The answer is, as a society, we understand the notion of competing harms. And we have decided that the harm to society in permitting the introduction of illegally seized evidence portends harm to our notion of a free society. The guarantees of the Fourth Amendment would be vitiated if we allowed police to use such evidence. The protection it offered would be eviscerated. So we understand that in order to preserve a societal framework in which police must at least pretend to observe the strictures of the Constitution is a moral good, as well as a practical one. And if all that is true, then my job was, and yours still is, to function as the advocate for the accused in such situations. Without zealous advocacy, again, all the aspirational language about the right to counsel, the right to avoid self-incrimination, the right to confront witnesses, all of these would be merely magnificent, but meaningless poetry, without someone giving them life. You're fighting for the ability of our society to remain free, fighting against erosion of rights that would otherwise begin with the most powerless and unpopular defendants. It's just like First Amendment advocacy. Popular speech seldom needs zealous advocacy, precisely because it enjoys popularity. To preserve the lines, the norms, we must advocate for the same protections for unpopular speech, which is not shielded by popularity. Story 8. A 13-year United States public defender shares their experience, stating that defending guilty clients is easy, as it's the government's failure if they cannot convict. However, they find it deeply troubling when clients they know are innocent plead guilty, which keeps them up at night. The defender emphasizes the presumption of innocence, tracing its roots to ancient Babylonian laws older than the Ten Commandments, underscoring its fundamental role in society. They argue that the state must prove guilt beyond a reasonable doubt, rooted in the rule of law. This narrative, over 300 words, reflects a moral conflict where the defender regrets outcomes, innocent clients pleading guilty, due to their belief in the system's foundational principles, though it does not mention deliberately losing cases. Story 9. A defense attorney criticizes the article for assuming it is unethical to represent defendants, detailing their practice area and experiences with cases thrown out due to illegal searches. They sleep well knowing such actions deter future misconduct by officers, highlighting the public's misunderstanding, such as dismissing illegal searches if substances are found, without considering unreported violations. The attorney argues the United States justice system prioritizes letting guilty individuals go free over imprisoning the innocent, emphasizing the David versus Goliath dynamic against state resources. They clarify that criminal cases focus on whether the state can prove guilt beyond a reasonable doubt, not innocence, aligning with their and other defense attorneys' mindset. This discussion, over 300 words, addresses moral beliefs in upholding constitutional rights, but does not explicitly mention deliberately losing or regretting wins. Story 10. Prosecuted a homicide case. 21-year-old kid starts dating an older guy's ex-girlfriend. The older guy, real roughneck, loose connections with a local biker gang, was going all over his small town talking about how he was going to kick the kid's ass. The older guy sends some inappropriate photos of the ex while he's getting drunk at a bar, so the kid says something smart-ass in response. Older guy comes to the kid's house to fight him. The kid shoots him once, and the older guy dies. Jury didn't buy self-defense or castle doctrine. Convicted of voluntary manslaughter. 20 years. Burned up his appeals with no luck. I have a son about the kid's age. I could totally imagine him doing the exact same things if he were in a similar situation. Stuff's gonna haunt me until I die. No doubt about it. Started thinking about other work the moment the verdict came back. Story 12. I was only a part on our trial team, meaning I just drafted pleadings but didn't do the stand-up work at trial. But there is one case that really showed me I'll never work for the man again. The case basically involved a little girl with massive disabilities. Mind of a baby, no talking. Motor skills/strength of a baby. Pretty much can't do anything on her own at all. Who had been supposedly harmed by her caregiver. The caregiver worked for a state agency, and we were the firm that did all this agency's litigation. To make a long story short, no one at this agency knew what on earth they were doing, and the actual caregiver had no training whatsoever in dealing with special needs children. This was in a really remote area, and they hired the caregiver at the last minute knowing she wasn't qualified. The girl's disabilities were so bad that it would honestly be hard to say whether or not she was actually harmed by the substandard care. That isn't the bad part. The bad part was how much money all this stuff cost. The state spent nearly $100,000 modifying its facilities so the girl could get in, out easier, and use the restroom easier. We, because we had to, in order to defend the case, hired all these experts on disability law, medicine, neuroscience, psychology/psychiatry, etc. I don't know if you guys know how much experts cost, but it is routine for us to pay $30,000 or so for a report and a few hours of testimony in court. This case had at least 4 experts that testified for us. So the state spent a bunch of money before the case started trying to help the girl. Then we spent a ton of money defending the case. Oh, did I mention we had at least 6 lawyers on the case, including 2 partners? On top of this, the girl's family obviously had to hire lawyers to fight ours, so I'm sure they spent a lot of money too. Their representation was on a contingency fee, but they are still responsible for these sorts of costs, and they were poor as hell. I'm talking about scraping the bottom of the barrel poor. They were from a very remote area, lived in a rundown house, and neither parent had a job. They pretty much survived because of the government checks that paid them to be their daughter's home health aide. Nonetheless, they certainly incurred a ton of expenses even if their lawyers were paid on contingency. Needless to say, we won at trial. It should have never gone to trial, but that is a story for another day. I didn't go to most days of the 2-week trial because I had to work, and I'm too junior to be trial counsel in federal court. I did, however, go to hear closing arguments and the verdict. When I heard the verdict, the first feeling I had was one of mild relief. It is important for the firm that we win cases that. Story 13. Had a client who had been convicted of sexual assault and was just finishing up his prison sentence. The state was pushing to have him declared a chronic offender and have him civilly committed after he got out of prison. But he didn't quite meet the criminal history criteria. We won on that one, but less than a month later he was arrested for assaulting a sex worker who was also an addict. I don't regret representing him. The state should never be allowed to bend the rules on imposing a penalty as drastic as permanent civil commitment, but I do regret that the law didn't make adequate provision for dealing with guys like him. I'll also always wonder if the second victim wasn't a setup. I wonder if somebody in the county prosecutor's office didn't tell her what kind of history this guy had with teen and preteen girls and offer her a get-out-of-jail-free card or substances out of the evidence locker or something if she'd help stick him with a charge that would qualify him for permanent commitment. Story 14. I do juvenile work, criminal law, and family law. I represented this client first when he was a juvenile charged with disorderly conduct at school and fighting. Then when he became an adult, was for simple things like possession of a substance. As he got older, it became easier and easier to figure out what part of his life hasn't gone as well as it could, and I tried to counsel him and push him to better himself. He got his GED, high school equivalency diploma. He started going to NA, Narcotics Anonymous. He started classes at a community college and found a part-time job. On the night of his 21st birthday, he was charged with a DWI, driving while impaired. Of course I'll take care of that too. About 6 months later, we are due in court for trial on a Monday, and he doesn't show up, which at this point in his life is highly unusual. As I'm trying to figure out where he is, the court starts going over arraignments/first appearances, and then lo and behold, 3 people are up for homicide charges. The prosecution starts to tell the judge what the facts/circumstances of the case are, and mentions a few victims' names. Apparently, my client was at a party when these 3 individuals decided to allegedly do a drive-by shooting. My client suffered multiple gunshot wounds and didn't make it to the hospital. So, by default, as you can't prosecute a dead person, the state has to take a dismissal. I guess technically a win. Either way, it was crushing to me, as I thought he had really turned his life around. He had. Eat it. Wow, this really blew up. Thanks for all the positive comments. And the bling. Also, since some people asked for clarification or were confused. 1. I truly believe he was on the right path forward. This video does not promote illegal activity. Stories are shared for commentary and education.